Welcome. I'm Rachel Wright, and I'm with our estate planning and probate group here at Beresford Booth. Today, we're talking about something that everyone experiences, but very few people plan for. What happens after we die? We'll cover the choices you can make about your final arrangements and the disposition of your remains, and just as importantly, who legally gets to make those decisions for you in Washington if you never put your wishes in writing. So why does it matter to make a plan? Planning your final arrangement sits in the same drawer as cleaning out the garage. Everyone agrees it should happen, and almost everyone avoids it. But you're the guest of honor at this event, and without a plan, you may have no say in how it goes. The reality is that someone will have to make these decisions. The only question is whether those decisions will be made by you or the people you leave behind. So why shouldn't that someone be you? Grief makes people weird. Planning helps. Even the most reasonable, level-headed families can make surprising decisions when they're grieving. People forget conversations, remember things differently, or become absolutely convinced that they know what you would have wanted. None of this is about being morbid. It's about being clear. Grief affects everyone differently, and when there are no instructions, people naturally fill in the blanks themselves. That's often where misunderstandings, guilt, and family conflict begin. A written plan gives the people you love something incredibly valuable: direction. It removes the guesswork and gives them permission to stop asking, what would they have wanted, and start saying, we're carrying out their wishes. So first, what happens to you? For most of human history, there weren't many choices. Family buried you, and that was that. Today, though, you have options. A lot of options. Most people know the classics: burial and cremation. But the menu has expanded. There is also green burial and human composting, which lets the body return to the earth naturally, and it is exactly what it sounds like. Or perhaps you would like door number 4, alkaline hydrolysis or water cremation, which is an eco-friendly alternative to traditional flame creation. Whether you've always known exactly what you want or you've never given it a second thought, it's worth understanding what's available, because you can't choose an option you don't know exists. And that's really the point of all of this. There isn't a right answer. There's only the answer that's right for you. Then there's the question of where. Final resting place sounds poetic, but it's a real decision with emotional weight for the people left behind. Do you want to be buried in a family plot, scattered at your favorite beach, returned to your hometown? Or if you're feeling adventurous, strapped to a rocket and launched into space? Where you end up can determine whether your family has a place to visit, a place to gather, or a place to tell stories about you. And for many families, that place becomes part of the grieving process. There isn't a right answer here either. Some people want a destination, others want freedom. The important thing is that your arrangements feel like you. And then there's the party you headline, but you don't actually attend. The celebration of life, memorial, wake, or whatever your family chooses to call it. This is your final event, and it can be as traditional, unconventional, solemn, or joyful as you want it to be. If you want barbecue instead of finger sandwiches, say so. If you want dancing, say so. If you want to have a playlist that absolutely must include a certain song, or absolutely must not include a certain song, say so. And if your family includes a few people who tend to grab the microphone and tell stories that should never be told in public, a strict no open mic rule is perfectly acceptable. The point is that your loved ones shouldn't have to guess. Give them the roadmap, put it in writing, and make your last party feel like you. And religious and cultural considerations matter too. For some people, certain rites are deeply important: a particular clergy member, specific prayers, or burial within a certain time frame. For others, the idea of a formal religious service is the exact opposite of what they would want. And here's something that is surprisingly common. You don't have to be religious in life to want a religious exit. Maybe faith became important later in life. Maybe certain traditions connect you to your family or culture. Or maybe there is simply something meaningful about those rituals at the end. That's all valid. All of those choices are valid, but they can only be honored if someone knows what they are. Without direction, families tend to default to what they assume you would have wanted. Sometimes they're right, sometimes they're very, very wrong. A few simple instructions can spare your loved ones from having to guess and help ensure that your final arrangements actually reflect you. But that raises an important question. If you don't leave those instructions, who gets to decide? In Washington, if you don't make these decisions yourself, the law decides who gets to make them for you. Under RCW 68.50.160, the person with the right to control your remains decides the time, place, and manner of your disposition. That's not just who picks up the urn or signs paperwork. That person gets to make the big decisions, burial or cremation, where your remains go, and what your final arrangements look like. The good news is that you don't have to leave that decision to chance. Washington law allows you to sign a written witness document naming the person you want to have that authority. In other words, if there's someone you trust to carry out your wishes, you can choose them. And if there isn't, well, the statute has a list, and we're about to talk about it. So without direction, the list is first, your spouse or domestic partner, then a majority of your adult children, then your parents, then your adult siblings, and then a court-appointed guardian at the time of death. So that's the list. It's a tidy little hierarchy, assuming your family actually fits into one. But the reality is that most families don't, at least not perfectly. Families are blended. People are estranged. Some relatives haven't spoken in years. Some people have one person they trust and several they'd rather keep far away from these decisions. The statute doesn't ask whether the surviving spouse and the children get along. It doesn't ask whether the parent at the top of the list is the parent you would have chosen. It doesn't ask who knows your wishes best or who's most likely to honor them. It just runs the list. And if you're perfectly happy with the person at the top of your list, that's great. But if you'd rather give control to someone else, or as I like to say, anyone but mom, you need to put that in writing. Otherwise, the law will make the choice for you. So what does in writing actually mean? Exactly what it sounds like. A conversation doesn't count. Not if it was with your spouse or partner, not if it was a clear talk at Thanksgiving, not if it was with your best friend who has known you since you were 12 years old. Because after you're gone, memories fade, stories change, and people remember conversations differently. What counts is a signed witness document expressing your wishes, setting forth those wishes concerning the place and or method of disposition. In other words, the law doesn't ask, what do we think they wanted? It asks, what did they put in writing? And sometimes the group project is the right answer. The default is one decision maker, but it doesn't have to be. As a general rule, I do not recommend turning estate administration into a group project, but there are always exceptions, and this is one of them. If it matters to you that all of your children are involved or that nothing proceeds without notice to certain people, you can build that into your written direction. You can require agreement. You can require that everyone has a chance to be there before anything is finalized. The alternative is worse than people expect, not disagreement, but someone finding out after the fact that the burial already happened, the ashes were already scattered, or the service already took place without them. This is not the kind of things families recover from easily, and it is entirely avoidable with a few sentences in a written document. Ultimately, all it takes is a signature and a witness. Skip it, and Washington law will choose your decision maker using a list that's never met your family and knows nothing about your relationships, your values, or your wishes. And remember, grief makes people weird. A written plan is one of the simplest gifts you can leave behind. It gives your loved ones clear instruction, removes unnecessary uncertainty, and lets them spend less time guessing and more time remembering. After all, if you are going to be the guest of honor, the least everyone can do is follow your instructions. If you'd like help putting your wishes in writing, do not hesitate to reach out. Have a great day.